The second characteristic of a penal law is the principle of territoriality. What is this principle of territoriality? It simply means that our penal laws can only be applied and enforced within the limits of our Philippine territory, subject of course to certain exceptions. In my previous video, I have already extensively discussed what constitutes our national territory. So much so that we have come to the conclusion that our national territory comprises the following: the Philippine archipelago and its internal waters, meaning everything inside the baselines, including the airspace above said islands and waters, territories over which the Philippines has sovereignty or jurisdiction like the Scarborough Shoal, the Spratlys, and Sabah. Although, as I have mentioned in that video, these territories are still disputed territories, but insofar as the Philippines is concerned, we consider them as part of our national territory. We also have the territorial sea, including the airspace above it, and the seabed, the subsoil, the insular shelves, and other submarine areas under the territorial sea and internal waters. Also take note that the following maritime zones, contrary to popular perception, are not part of Philippine territory: the contiguous zone, the exclusive economic zone, the continental shelf, the high seas, and of course, the airspace above these maritime zones. Since they are not part of our territory, we therefore do not exercise sovereignty and jurisdiction over them. Hence, our penal laws cannot be applied and enforced within these maritime zones, subject of course to certain exceptions under Article 2 of the Revised Penal Code, as well as for the purpose of enforcing our economic rights within the said zones. Now, what is the scope of application of the principle of territoriality? The principle of territoriality has both intra-territorial application and extra-territorial application. When we say intra-territorial application, it simply means that our penal laws shall be applied and enforced within our national territory except as provided in treaties and laws of preferential application, and also by virtue of the principles of public international law. For example, X, a court stenographer of the RTC of Pasig, falsified the transcript of stenographic notes to make it appear that Y admitted to the commission of the crime when in truth he did not make such admission. X here is subject to our penal law on falsification of official documents because the crime was committed in Pasig City, which obviously is a part of Philippine territory. Example number 2. X, an Italian ambassador to the Philippines, killed his spouse Y while they were inside one of the rooms at the Manila Hotel. This is a clear case of parricide insofar as our penal law is concerned. However, since an Italian ambassador has full diplomatic immunity as provided in treaties like the Vienna Convention on Diplomatic Relations and laws of preferential application like Republic Act 75, he cannot be charged and prosecuted in the Philippines. Example number 3. Another example of a law of preferential application is Article 145 of the Revised Penal Code. Members of Congress enjoy immunity from arrest while Congress is in session. This means that they cannot be arrested unless it is for a crime punishable by more than 6 years imprisonment. This immunity covers both arrests by virtue of a warrant, and also warrantless arrests. It includes offenses committed prior to a senator or congressman's election and during his or her incumbency as such senator or congressman for as long as such offenses do not have an imposable penalty of more than 6 years imprisonment. Now, when we say extraterritorial application, this is found in the second part of Article 2 of the Revised Penal Code, which states that the provisions of the Revised Penal Code shall be enforced also outside of Philippine territory against those who should commit an offense, number one, while on a Philippine ship or airship. Number two, should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the Philippine government. Number three, should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. Number four, while being public officers or employees, should commit an offense in the exercise of their functions. Or number five, should commit any of the crimes against the national security and the law of nations as defined in Title 1 of Book 2 of the Revised Penal Code. We shall endeavor to discuss each of these instances in the succeeding slides. The first instance where our penal laws are given extraterritorial application is when an offender commits an offense while on a Philippine ship or airship. When we say offense, it refers to any crime, whether it be a felony under the Revised Penal Code or an offense punished under special laws. For example, let us say X is found to be in possession of an unlicensed firearm inside or while in that Philippine ship or airship. Even if that Philippine ship or airship is already outside of our national territory, still X can be charged and prosecuted here for the crime of illegal possession of firearms, because this is an instance where our penal law on illegal possession of firearms can be given extraterritorial application. When we say Philippine ship or airship, it simply means that it is one that is registered in accordance with Philippine laws. And in particular, with respect to vessels or watercrafts, they must be registered with the Bureau of Customs. It is therefore the country of registry, not the ownership of that particular ship, that is used as basis to determine whether a ship or an airship is a Philippine ship or airship. Meaning, once it is registered under Philippine laws, it is given the nationality in the country of its registry, the Philippines. That ship will now be allowed to carry or hoist the Philippine flag. For example, a Russian-owned ship which is registered in accordance with Philippine laws is considered a Philippine ship, not a Russian ship. What are the two kinds of Philippine ships or vessels? The two kinds of Philippine ships or vessels are the Philippine warship and or the official vessel of the President, and the Philippine merchant vessel. If it is a Philippine warship or the official vessel of the President, these ships are considered under international law as extensions of our national territory. Hence, whether the ships are in the contiguous zone or in the exclusive economic zone or even if they happen to be in the high seas, or even if they are in the territory of another country, whenever a crime is committed inside these ships, Philippine penal laws apply. Does this rule apply to Philippine fighter jets and the official airplane of the president? By analogy, the answer is yes. Why? Because the provision itself, Article 2, mentions of an airship, which is by all means can be considered as an airplane. Now, if it is a Philippine merchant vessel, meaning a watercraft that transports cargo or carries passengers for hire, it is obvious that when a crime is committed inside the vessel and the said vessel is within the archipelagic waters or internal waters, or the said vessel is within the territorial sea of the Philippines, Philippine penal laws apply. And even if the said vessel is in the contiguous zone or in the exclusive economic zone or in the high seas, Philippine penal laws still apply. The reason is Article 2, Paragraph 1 of the Revised Penal Code, which states that our penal laws shall be enforced outside of Philippine territory against an offender who commits an offense while on a Philippine ship or airship. This is the first instance, like what I said, of extraterritorial application, or where our penal laws are given extraterritorial application. Take note of this. But when a crime is committed inside the Philippine merchant vessel, which happens to be in the territory of another country, which country has jurisdiction? The Philippines or that foreign country? The answer to this can be found in knowing the two recognized rules on jurisdiction. And what are these two recognized rules on jurisdiction? They are the English rule and the French rule. What is the difference between the English rule and the French rule? The English rule adheres to the territoriality or situs of the crime. The foreign country or the host country has jurisdiction over crimes committed inside that merchant vessel unless they involve the internal management of the said vessel, in which case the country where the said merchant vessel is registered has jurisdiction. For example, X, working as a cook inside a Philippine registered cargo ship which happened to be docked at a Chinese port, trafficked drugs by purchasing 3 kilos of shabu from Y, a Chinese national, inside the said cargo ship. Meaning, dun lang nangyari sa loob ng barko yung transaction between X and Y, a Chinese national. Bumili si X ng 3 kilos of shabu from Y, who went inside that ship and sold 3 kilos of shabu to X. Here, China's penal laws apply because the crime committed by X, drug trafficking, affects the order and security of China. Example number 2. X, working as a cook inside a Philippine registered cargo ship which was docked at a Chinese port, shot and killed his captain Y after the latter reprimanded him for his performance. Here, Philippine penal laws apply as the crime committed by X merely involves the internal management of the vessel. The French rule, on the other hand, adheres to the flag or nationality of the merchant ship. The country where the vessel is registered shall have jurisdiction over a crime committed inside the vessel, unless na lang the crime affects the peace, order, and security of the host country, in which case the host country shall have jurisdiction. For example, X, working as a cook inside a Philippine registered cargo ship, stole the gold bracelet of his co-seafarer Y while the ship was docked at a Chinese port. Here, Philippine penal laws apply as the crime committed by X did not affect the peace and security of the host country, China. Another example, Y, a pretty Chinese masseur who went inside a Philippine registered cargo ship while the ship was docked at a Chinese port, purposely to render a massage service on X, a seafarer working as a cook in the said vessel, was raped by the latter. So, ang nangyari dito, may isang Chinese na babae na pumunta doon sa barko na nakadock at a Chinese port, and then that Chinese woman was raped inside the vessel. The question is, who has jurisdiction? The Philippines or China? The answer to this question is, based on the French rule, is that Chinese penal laws apply as the crime committed by X affects the peace and order of the host country, China. Question: what if the crime happened inside a merchant vessel that is unregistered, meaning hindi lisensyado? Which country has jurisdiction? The answer is it depends. If the crime happened while the unregistered vessel is still in the archipelagic waters or internal waters or within the territorial sea, then there is no question that Philippine penal laws apply. And under the doctrine of hot pursuit, such vessel may be apprehended even if the same is already beyond the territorial waters of a state. Now, if the crime happened while the unregistered vessel is already beyond the territorial waters of a state, then any state for that matter can assert jurisdiction over the said vessel or over the crime that occurred inside that vessel. In an old case, however, in the case of U.S. versus Fowler, the Supreme Court held that Philippine courts have no jurisdiction over the crime of theft committed on the high seas on board a vessel not registered in the Philippines. Let us now talk about the second and third instances where our penal laws are given extraterritorial application. In the second instance of extraterritorial application, it happens when an offender forges or counterfeits any coin or currency note of the Philippines or obligations and securities issued by the Philippine government. And the third instance of extraterritorial application happens when an offender is liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the second instance. So I am now discussing this together, the second and the third instance. This refers therefore to the crimes of forgery under Article 166, which is the forging of treasury or banknotes or the forging of obligations and securities, as well as the importing of false or forged notes, obligations, and securities in relation to Article 169 of the Revised Penal Code. The second and the third instance likewise refers to the crime of counterfeiting coins under Article 163. They refer to the making and importing and uttering of false coins as defined and penalized under the Revised Penal Code. Both Article 166 and Article 163 are defined and penalized in the RPC. When we say coin, it is usually a flat, typically round piece of metal with an official stamp used as money. When we say banknote, it is a bill or a form of currency that one party can use to pay another. For example, a 500 peso bill or a 1,000 peso bill, they are called banknotes. When we say treasury note, it is a peso denominated short-term fixed income security issued by our government through the Bureau of Treasury. Now, these treasury notes pay a fixed rate of interest until the security matures, usually from 2 to 10 years, which is when the Bureau of Treasury will pay for their par value at maturity. When we say obligation or security of the Philippine government, they refer to all bonds, certificates of indebtedness, national banknotes, fractional notes, certificates of deposit, bills, checks, or drafts for money drawn by or upon authorized officers of the Philippine government and other representatives of value of whatever denomination which have been or may be issued by the government. So, I am discussing this to you now because these are the subjects, no, of the second and the third instances where our penal laws are given extraterritorial application. The forging or counterfeiting and importing of these coins, banknotes, and obligations and securities issued by the Philippine government. Under the second and third instances where our penal laws are given extraterritorial application, if the crime committed is forgery and importation of forged treasury or banknotes or other obligations and securities issued by the Philippine government under Article 166, or if the crime committed is counterfeiting Philippine coins and importation of counterfeited coins under Article 163, even if the said crimes are committed outside of Philippine territory, Philippine penal laws apply as the same is given extraterritorial application. So whether the forgery is committed in the Philippines or outside, for as long as the subject of forgery are banknotes or other obligations and securities issued by the Philippine government, or the subject of the counterfeiting are Philippine coins, meron pa bang nagka-counterfeit ng Philippine coins ngayon? I think wala na. Dahil sa liit ng value ng coins. But just the same, no, if what is counterfeited are Philippine coins, whether the counterfeiting is committed inside the Philippines or outside, Philippine penal laws apply. Again, take note that what must be counterfeited and or forged must be Philippine coins or Philippine banknotes or obligations and securities issued by the Philippine government. Otherwise, the second and the third instance will not apply. The fourth instance where our penal laws are given extraterritorial application is when a public officer or a public employee commits an offense in the exercise of his or her functions. Meaning to say, for as long as you are a public officer or a public employee, even if you happen to be abroad or you happen to be in the territory of another country, if you commit an offense in relation to your office, you can still be charged and prosecuted in Philippine courts. Now, who are considered public officers? A public officer is any person who, by direct provision of the law or by popular election or by appointment, shall take part in the performance of public functions in the Philippine government, or shall perform in said government public duties as an employee, or agent, or subordinate official of any rank or class. Take note of that. even a janitor who is an organic employee of, for example, the Department of Justice, is considered a public officer or employee. Covered siya under the definition. Now, when we say a public officer commits an offense in the exercise of his or her functions, what are these offenses that are committed by a public officer in the exercise of his or her functions? Examples are bribery, frauds against the public treasury, malversation, and falsification by a public officer. Take note, however, that the crime committed must be in relation to the exercise of his office. Otherwise, the public officer will be considered as acting in his private capacity and hence beyond the reach of our penal laws. For example, Fiscal X, while on vacation in South Korea, falsified the signature of his boss Y, the chief of office of the city of Manila, to make it appear that his boss approved his resolution recommending the dismissal of a drug case. Here, even if the act of falsification committed by X was made in South Korea, because in this example, X happened to be in South Korea when he made the falsification, X can still be charged of the crime of falsification because he is a public officer who committed an offense in relation to the exercise of his office. Example number 2. X, a DPWH official, was caught in possession of 5 sachets of shabu while on an official trip in China. Can he be prosecuted here in the Philippines? The answer is no. Our penal laws will not be given extraterritorial application because the crime committed by X is not a crime committed in relation to the exercise of his office. He will, of course, deal with the penal law on China. The fifth and last instance where our penal laws are given extraterritorial application is when an offender commits any of the crimes against the national security and the law of nations as defined and enumerated in Title I of Book 2 of the Revised Penal Code. What are then the crimes against the national security and the law of nations under the Revised Penal Code? We have the crime of treason under Article 114, conspiracy and proposal to commit treason under Article 115, misprision of treason under Article 116, espionage under Article 117, inciting to war and giving motives for reprisal under Article 118, violation of neutrality under Article 119, then we also have correspondence with hostile country under Article 120, flight to enemy's country under Article 121, piracy and mutiny under Article 122, and qualified piracy under Article 123. Thus, even if these crimes are committed outside of our Philippine territory, the revised penal code is given extraterritorial application, meaning to say the offender can be charged, prosecuted, and convicted if found guilty in our Philippine courts.